Good morning and welcome to our online webinar on COVID-19 Labour Law for Individuals. My name is Sarah Haffenden and I am the Marketing Communications Manager at UKZN Extended Learning, also known as UEL. In case you are unfamiliar with UEL, we are the continuing education unit of the University of KwaZulu-Natal, and we offer all of the short courses on behalf of the university. So we are offering these online webinars as we are in full support and compliance with the directive of a national lockdown. So we are embracing the changes and have been working on a number of projects aimed at providing free access to learning materials during this lockdown period. So one of these projects is our online learning webinars. So this webinar is a 4-part series focusing on labour law issues relating to COVID-19. This is the 3rd part of the series. The previous 2 webinars are available on our website, and we will also be launching 3 more series, which will also be 4-part webinars, which will continue throughout May and June. So please do take a look at our final slide at the end of this webinar for further details on upcoming webinars, or you can visit our website www.ukznextendedlearning.com. So I'd now like to introduce you to our guest speaker for today, Dr. Tamara Cohen. Tamara is a former Associate Professor of Labour Law in the School of Law at UKZN and is currently an Honorary Research Fellow at UKZN. She is an experienced labour law trainer and facilitator, a panelist of Equitate Professional Employment Law Solutions, specializing in labour matters, an accredited commercial mediator, and an admitted attorney. She has co-authored various labour law texts, including Labour Law Through the Cases, Labour Relations Law, Trade Unions and the Law, Labour Law in Context, and Laws Against Strikes, Strikes and the Law, and Labour Law, amongst others. Tamara has published many articles in the field of labour law in leading law journals and has presented conference papers both nationally and internationally. So Tamara has facilitated many workshops on various aspects of labour law. So welcome, Tammy, and over to you.
Employer's perspective, what their responsibilities are. So for those of you that have been attendees at the last 2 weeks, there might be some repetition. That's my disclaimer up front. But obviously there have been a whole lot of changes in the last week already. And every time I blink, there's some kind of a change or a new interpretation of the various regulations. So there certainly is going to be new aspects that are being discussed today. But from an employee's perspective, there are a number of issues that need to be considered and that are affecting employees, those that are still working and those that have now been part of the lockdown and been unable to work. I'm going to quickly run through what I'll be talking about today. I know this has been answered over the last 2 weeks, but for those that weren't here before, I'm going to discuss whether employers are obliged to pay their employees, whether the no work, no pay rule applies in circumstances where employees are willing and able to work, but not prohibited from doing so by the lockdown provisions. And briefly, I'm going to talk about benefits. So is the employer obliged to pay their medical aid, provident fund and pension fund contributions, and all sorts of other benefits, and specifically bonuses, which I'm going to talk about this morning too. Is an employee entitled to their annual bonus? There are a number of problems. The one, and we'll talk about this later, is that employees from a performance bonus perspective have literally not been able to perform due to no fault of their own, and also obviously from the angle of the employer's financial distress. Are they in fact in a financial position to pay those bonuses, and does this then impact on the employee's rights? I'll also be having a look at the UIF TERS scheme, which I have explained thoroughly in the webinars previously, and which can be watched again for those that need further clarification. But since my last webinar, there's been quite a lot of confusion and discussion about whether employers are entitled to top up benefit contributions received from the UIF, whether they can top up an employee's salary, or whether they are prohibited from doing so. As far as leave goes, I'm going to be briefly discussing whether employees have any say in being required to take their annual leave during this period, and whether an employer, when getting a TERS benefit from the UIF, whether the employer can then be compelled to pay back, essentially credit employees with their annual leave so that they still retain that benefit at the end of the day. I'm going to very briefly talk about self-quarantine and whether that would be regarded as sick leave for the benefit of the UIF contributions, and in fact for the from the aspect of depleting an employee's sick leave, particularly if an employee has already depleted their sick leave for genuine sick leave purposes. And then essential service employees, I'm going to talk briefly about the Compensation Act and the provisions that apply to the Compensation for Occupational Injuries and Diseases Act, and whether the protection that affords to essential services employees that contract the virus during their time that they are compelled to work. And then there's been a lot of new regulations that came out very recently, the 29th of April, insofar as they apply to occupational health and safety at the workplace, particularly seeing 1,500,000 employees went back to work since we have entered level 4. And there's all sorts of new requirements from an employer's perspective, and obviously from an employee's perspective too, to comply with health and safety requirements. So getting on with it briefly, as far as the no work, no pay principle goes, this entitlement of an employer to refuse to pay an employee's salary is based on a contractual provision which is referred to as a supervening impossibility of performance. I have spoken about this in previous webinars and explained that it is a common law principle that applies across the board, certainly not just as far to the employer-employee relationship. And what it really means is that contracting parties are excused from performing their contractual obligations when circumstances beyond their control, unforeseeable circumstances beyond their control, prohibit them from fulfilling their part of the bargain, their part of the contract. But what is required is not simply an inconvenience, but the performance itself must be objectively or absolutely impossible. It will not suffice that it becomes difficult, but where it becomes actually physically impossible, or a situation where it is so difficult that it cannot reasonably be expected to be performed, then parties would be excluded from their contractual obligations. And this, as I explained last week, that this also applies to performance of other contractual provisions, meeting manufacturing contracts. But in the employment context, employees that are not regarded as essential services are simply unable to render their services due to the governmental directive enforcing lockdown, and as a result of that, employers are in the same boat that they are contractually excused from making payment in that situation. So the bottom line is employers are under no legal obligation to pay their employees. You as employees really have very little legal rights to demand payment. Certainly if an employee works part-time, they're entitled to be paid pro rata for that work, for those hours of work. But if there's no work whatsoever being done by an employee, they really have to rely on the goodwill of their employer if they can afford to make payment, or wait for the employer to get compensation on their behalf from the unemployment insurance fund. And then as much as it is minimal compared to an entire salary, there is some kind of compensation paid at the end of the day, which ranges between approximately 30 to 66% of the employee's salary, depending 38 to 66 to be precise, depending on the salary scale of that particular employee. That goes some way to offset the damage of not receiving any income whatsoever in the circumstances. And then notice trite stating the obvious, but essential service employees that have had to continue working throughout the lockdown period are entitled to their full salary, irrespective of how much financial distress or challenges their employers find themselves in. As far as bonus payments and benefits, clearly from an employee's perspective, they very much rely on their bonuses, their annual bonuses, whether it's a 13th check or a performance-related bonus, which constitutes part and parcel of their remuneration. Most of these bonuses are included in their contractual provisions. Their employment contract would make provision for this. And the question arises, down the line, are they entitled to demand the payment of these bonuses towards the end of the year or whenever these bonuses become due? It is well known that companies are going to suffer enormously. The effect of the lockdown is going to be catastrophic for small and medium-sized enterprises, but even for larger enterprises. And they will be doing everything they can under the circumstances to avoid retrenching or in fact closing down entirely, which is, we've already seen a trend towards that in the last few weeks. So it's a very difficult question. Is an employee entitled to demand payment of those bonuses under the circumstances? Well, just as far as bonuses go, there are two different types of bonuses. One is what is referred to as a discretionary bonus, and it's really up to the employer to exercise their discretion depending on their financial circumstances, on their impression of that employee's contribution to the success of the workplace in a particular year, whether or not to pay bonuses. In such a situation, there is a good cause for an employer to exercise their discretion not to pay bonuses, perhaps this year and even in years to come, if their financial circumstances dictate, if their financial circumstances justify such non-payment. All that would have to be required to be proved by an employer in such situation is that that discretion has been exercised rationally, fairly, and in good faith. In other words, there's been no victimization, there's been no discrimination, there's been no jumping on the bandwagon of everybody else facing financial distress and trying to generate a profit. Obviously playing devil's advocate. If it's a discretionary bonus, then I would say under the circumstances with the COVID lockdown, with the pandemic, with its effect on the economy, that the employer would be well justified in refusing to pay bonuses or in reducing bonuses under such circumstances. However, if a bonus is contractually provided for, it forms part of the employee's contract of employment, it's been habitually paid year in and year out, the employer would not be able to unilaterally refuse to pay the bonus in those in the COVID circumstances, even if there are financial challenges being faced by the company. I will come back to this later when I will briefly talk about retrenchments and what could well be on the cards for many employees and employers down the line. But an employer cannot unilaterally refuse to pay a bonus. What they would have to do is to engage in discussions and consultations with their employees to try and negotiate either a delayed bonus payment or no non-bonus bonus payment, or perhaps a reduced bonus payment in the circumstances. If employees refuse to agree to the suggestions being made by an employer in this regard, then the employer would have no option but to commence operational requirements dismissal procedures. In other words, they would have to start retrenchment consultations, and perhaps the non-payment of bonuses or benefits would be the outcome instead of a retrenchment. But that is the only legally sanctioned circumstances in which bonuses can be changed. If it's arisen out of a retrenchment consultation, or it's pre-retrenchment where there's been discussions and consultations with employees and they've agreed to a variation or a waiver of their entitlement to bonuses. Just going up, I've skipped over one or two lines in the slide, but from a pension and provident fund contribution perspective and medical aid contribution perspective, when an employee is not being paid as a result of this supervening impossibility of performance that I've spoken about, the employer is also under no obligation to make pension, provident, and medical fund contributions. However, the various sectors, the financial sector conduct authority and the Council for Medical Schemes, have actively encouraged employers to do what they can under the circumstances to make the contributions that they can, and the funds and the medical schemes have also been actively encouraged to provide some leeway, to give some temporary reprieve under the circumstances to these funds and to these employers under the circumstances. The unfair labour practice provisions of the Labour Relations Act, which I've put at the very first bullet point on this slide, section 186(2), talks about it being an unfair labour practice if there's unfair conduct relating to the provision of benefits, which clearly includes all of these contributions that I've spoken to, as well as bonuses. And the onus is on the employer in those circumstances to prove that what their non-payment or their reduced payment is fair under the circumstances. So the onus would lie on them to justify their non-payment, failing which it would be a matter that could be referred to the CCMA as an unfair labour practice, and it can be referred within a 90-day period of the unfair labour practice occurring, and can result in compensation being awarded of up to 12 months, depending on the circumstances and the opinion of the commissioner if they feel that an unfair labour practice took place. As far as leave provisions go, yes, sorry, I'm forgetting about our poll question. We have a quick poll question that would very much appreciate if you entered at this stage. The first question is, have you been receiving your full remuneration during the lockdown period? The choices are yes, no, and I've been receiving partial payment. And the answers to this are very relevant when I talk about the TERS benefits in a slide or two to come. If you could perhaps just, it does say host and panelists cannot vote. Okay, that's perfect, we get that. But if those of you that are attending, if you could enter your results there, it would be appreciated. I don't see anyone entering. I think we might have a system problem, so perhaps we could just take that poll question down if possible and continue. Okay, perfect. Let's just go on. I think we might just have a slight system issue with people completing the poll.
I have the results, Tammy.
Oh, okay.
83% yes, 3% no, and 14% receiving partial payment.
Okay, so at this stage, it looks like people are, for those that are attending, are still receiving their payment, which is fantastic news for those concerned. But the unfortunate part is we don't know how long this lockdown will continue and whether employers are going to be in a financial position to continue in that regard. And if they aren't, then we need to have some discussion around the TERS benefits and what employees are entitled to in terms of these TERS benefits and whether they're entitled to top-ups to these TERS benefits. So I'll get to that in one slide's time. As far as leave provisions go, employees can be forced to take their annual leave over this period, while the Basic Conditions of Employment Act specifically suggests and requires as a first off that annual leave be taken in accordance with an agreement between employers and employees. When there is no agreement or agreement is not possible, then this can be required to be taken by the employer at a time determined by the employer. And it seems that this is the first port of call for employers, is that they're immediately, where cash flow permits, requiring their employees to treat this lockdown period when they're unable to work, when employees are unable to work in any way, they are treating this as annual leave. But clearly, annual leave is 21 continuous days or 15 working days for those working on Monday to Friday, and that has certainly now been depleted as our lockdown exceeds 5 weeks. And so that option has now effectively terminated. As far as an amended directive to the UIF regulations that came out on the 16th of April, employers will be able to claim a TERS benefit through the UIF, and if they receive the benefit and they at the same time have required their employees to take their annual leave during the lockdown period, they will be in a position that they can in fact credit those employees back their annual leave that is obviously proportionate to the benefit paid by the TERS scheme. So it might in fact be a temporary measure that there can be a reversal of the use of that annual leave. But it's, as I said, it's certainly not going to fill, it's certainly not going to fill that entire gap, because there are limitations to the maximum benefit claimable in terms of the TERS scheme. And then sick leave, if an employee has been in precautionary self-quarantine outside of the lockdown period, they have felt that they might have be showing some kinds of potential infection, that they might have a sore throat or a cough, and they've decided to put themselves in precautionary self-quarantine, that will be regarded as sick leave, irrespective of whether it is just neurosis, because I've convinced myself on multiple occasions that I've definitely got COVID-19. I coughed once, and I was most certainly sure that this was the beginning of the end. But precautionary self-quarantine, it does not have to be authorized by a doctor. The first 14 days can simply be authorized by an employer, and only when it exceeds 14 days would medical intervention, a medical report, be required in those circumstances. Sick leave, though, would be treated as ordinary sick leave claim in terms of the UI Unemployment Insurance Act, and the fund does pay that off UIF credits, so that depends on how many credits a particular employee has clocked up over the years of work, and it also is paid on a sliding scale. Going on to the next slide, I have spoken quite a lot about the TERS, the Temporary Employer Relief Scheme, in our previous 2 webinars, and so I'll do a very abridged version this time round. But if you do require any further information or further clarification, those earlier webinars are available on the UEL website. But in a nutshell, if an employer does have to or had to during the lockdown period close their operations entirely or partly, they are entitled to claim benefits on behalf of those employees from the UIF. It doesn't matter that those specific employees are not necessarily even registered with UIF, as long as the employer is. It also doesn't work off credits, so it's a stand-alone benefit. It is completely disconnected and delinked, as they use the terminology, from the ordinary UIF benefits. And there is a cap on the amount that can be claimable. It's capped to a maximum amount, effectively, of employees earning a maximum amount of 17,712 Rand per month. So even an employee that's earning 20,000 will be capped at the 17,000, and they're only entitled to 58% of that amount, which converts to 6,730 Rand. I'll talk about the top-up issue in a minute, but from a minimum amount, the national minimum wage amount of 3,500 Rand will apply. So every single employee that falls under an entitlement to claim in terms of the TERS scheme will be entitled to a minimum amount of 3,500 Rand. Now, there was all sorts of, in a sense, what I almost regard as fake interpretations, fake news about whether an employer is entitled to top up over the TERS benefit. In other words, by way of an example, if an employee was ordinarily earning 18,000 Rand a month and the employer gets on their behalf a contribution from the Unemployment Insurance Fund of 6,730 Rand, can the employer then top it up? Not necessarily even up to the full remuneration, but can they top up what they've received from TERS? And there was a lot of misunderstanding of this provision, which has now been clarified, and the answer is yes. The employer can most certainly top up, provided the top up doesn't exceed what the employee would ordinarily earn by way of their remuneration. So provided the top up simply takes them, in the example that I've given you, to 18,000 Rand per month, that is absolutely acceptable in the circumstances, provided it doesn't exceed that amount. So all that controversy seems to have finally been clarified, and employers are welcome to do that if they can afford to. As far as short-time and reduced working time options, this is another provision that is envisaged by the Unemployment Insurance Fund under a separate provision that's been in existence since 2018, where an employee that is put on short-time, and short-time is defined as a temporary reduction in the number of ordinary hours worked, and this can be attributed due to seasonal demands, the slackness of trade, but clearly in this particular situation, it very much applies to employees that are unable to work at all during the lockdown period. And what the fund allows is for payment to be made. It's not a full benefit, it's not full salary, but it's on the sliding scale again, where employees are entitled to some form of payment to make up for the reduced working time, their reduced hours, but it is limited to the amount that the employee, and this takes a little bit of clarification for those of you that are unfamiliar with the Unemployment Insurance Fund benefits, but if an employee becomes wholly unemployed, they would be entitled to a specific amount, which is calculated between the 38% and 60% sliding scale. If they work reduced working hours that take them below what they would have ordinarily got for not working at all, they can effectively be topped up by the unemployment insurance fund for that shortfall. So that is another option. I think it's very much a secondary option, A, because it works with credits, B, because it's more complicated to actually prove, and C, because that claim needs to be made by the employees, whereas from the TERS benefit side, those claims have to be, and applications have to be submitted by the employers. So it generally makes life a lot easier for employees in such circumstances. Moving on to the next slide, and this is something I really did want to spend a little bit of time. Sorry, I'm forgetting about all my poll questions today. The next poll question is, has your employer applied to the UIF for TERS benefits on your behalf? And your options are yes, no, and the third option is, I have been working throughout the lockdown. If you could just give some thought to this and answer those questions. And Sarah, when the answers come in, please let me know, because it's not coming up on my screen at all.
Just, it's looking like a large majority have been working throughout the lockdown. So we're looking about 63%, and then 25% no, 13% yes.
Okay, all right. Well, that again is good news. It looks like our attendees are in a better position than very many employees in the country. The latest statistics are that they're projecting that between 3 and 7 million, I don't know if it's an exaggeration, but between 3 and 7 million employees could end up losing their jobs as a result of the lockdown and beyond. And that takes me to the next poll question is, do you anticipate that your employer may have to retrench due to the financial distress, the economic impact of COVID? So your options again are yes, no, and it's a possibility if the lockdown doesn't end soon.
Okay, for this one, it's 56% no, 30% it is a possibility if lockdown doesn't end soon, and then 15% yes.
Okay, all right, great. So this might be of relevance to this discussion that's coming up. I don't think any company is completely immune from the possibility down the line of retrenchments or alternatives to retrenchments taking place, whether it is simply just a reduction in bonuses or reduction in time off. All of these are alternatives that might be considered to retrenchment down the line. I'm sure some of you are familiar with the labour legislation, but retrenchments are very strictly regulated by Section 189 of the Labour Relations Act, which puts in place procedural steps that have to be complied with, failing which it will be regarded as an unfair retrenchment and unfair dismissal for operational requirements, which will be referred ultimately to the CCMA and then ultimately to the Labour Court, and can attract a variety of sanctions, one being reinstatement if retrenchment was inappropriate, but more likely compensation up to 12 months compensation. So the steps are put there. They're very unlike the other dismissal provisions, which simply state that dismissal should be for fair reason and fair procedure. The Labour Relations Act sets out step-by-step requirements for fair retrenchments, and part and parcel of these requirements, in fact, the entire ethos around retrenchments is the notion of joint problem seeking. So employees need to be notified by the employer of the intention to, or the possibility of retrenchments having to be considered. It cannot be a foregone conclusion. The employer is not allowed to decide, we are retrenching, now we're going to discuss the implementation of that retrenchment. That in itself would render it it would render it an unfair dismissal, an unprocedurally fair dismissal, unfair dismissal purely by virtue of the fact that the decision was taken prior to consultation. So consultation and joint problem seeking is a very, very big part of the requirements. The employer and employees, whether through their representatives or individually, depending on the nature of the workplace, have to try and reach some form of consensus on appropriate measures, A, to avoid retrenchments altogether, which is the ideal, or to minimize the dismissals in terms of numbers or impact, to change the timing of the dismissals, mitigate the adverse effects, and if retrenchments are indeed on the cards, also have to have some kind of agreement on severance pay. While severance pay is regulated by the labour legislation, there's still ability for consultation on improved severance pay from the minimum of 1 week for every completed year of service. The consultation needs to look at improvements on that. So the starting point would be the issuing of a Section 189(3) notice, which kicks off the consultation process. In the case of large-scale retrenchments, and this is a formula that depends on the number of employees at a particular workplace and the number of retrenchments envisaged. If the employer employs more than 50 employees, up to I think it's 200, and they intend to retrench a minimum of 10 employees, this Section 189 capital A large-scale retrenchments provisions apply, which in actual fact put in place a 60-day consultation period and require a facilitator from the CCMA to intervene. So it's not a short and quick solution process. It is one that's very, very well interrogated to see whether retrenchments are in fact required or not. And then as far as what I spoke about earlier, the entitlement to withhold bonuses, it's at this stage when retrenchment consultations are engaged in that there can be some discussion about whether or not withholding bonuses or not allowing an inflationary increase for the next 2 years on salaries. Just suggestions like that might be an option under the circumstances instead of retrenchments, but that would all take place within the retrenchment framework, within the consultation framework itself. Now, there is another provision in the Labour Relations Act, which is Section 187(1)(c), which has always made it an automatically unfair dismissal if employees are dismissed because they refuse to accept changed terms and conditions. In other words, if the employer at the consultation process says, we now would like you all to take a reduction in a 25% reduction in your salary, and if you don't accept that, we will dismiss you, that is undoubtedly would fall in the category of an automatically unfair dismissal. So a lot of employers have expressed concern and asked for legal opinion on whether, if they engage in a consultation process and they later on down the line then move towards retrenchments due to the failure of this consultation process, that the suggestions that they've made to change terms and conditions have failed, will they then be committing an automatically unfair dismissal at the end of the day? And the courts, this has been something that's been the subject matter of many court decisions prior to this particular lockdown scenario. And the general rule is, if the purpose of the dismissal was directly linked, causally linked to the operational requirement, the fact that earlier consultations failed and earlier attempts were made to change terms and conditions were refused or unsuccessful, refused by the employee, that would not constitute an automatically unfair dismissal. But there needs to be a clear causal link between the retrenchments itself and the operational requirements, and not in a sense to punish those employees for not accepting the changed terms. Going on, in terms of the Compensation for Occupational Injuries and Diseases Act, I did also cover this briefly last webinar. The COVID-19 has been declared to be an occupational disease. It came out very close to the start of lockdown, the amendment to the regulations. As with any occupational disease, the compensation fund is obliged to remunerate, to pay compensation to employees that are contract the virus in their workplace or arising out of their working circumstances. And the amount that they pay really ranges, it's again a scale, but it's approximately 75% of that employee's salary. The employer themselves is obliged to remunerate the employee for those days of absence, but the compensation fund will essentially pay that amount and will offset the employer's expenses. The compensation fund they've capped the amount of time that they will pay this amount up to 30 days, but I think that there could be challenges in this regard as the lockdown goes on indefinitely, and as depending on the recovery of employees from the COVID virus themselves. It involves all sorts of applications, but as employers have always been required to do for employees contracting occupational injuries and diseases, medical reports, etc., and that is required to be done by the employer on the employee's behalf. And then finally, almost finally, as far as essential service employees, and we now know that what is regarded as essential services goes way beyond the traditional understanding of what constitutes an essential service, which has traditionally been to preserve life, safety, health of the population. It's extended well beyond that to banking, financial, insurance, municipal services. And as a result of that, that is why 1.5 million employees went back to work in the last week, because that net of essential services has been widened. So the question that I've posed, and I posed this previously in a webinar, is what if an essential service employee refuses to go back to work? If they are concerned about exposing themselves to the virus, taking the virus home to their elderly parents or to their children, can they simply refuse to go back to work, or would this constitute insubordination? And this is something I've been asked on multiple occasions in the last few weeks. And the answer is that it would constitute insubordination unless the employee can show that they had reasonable grounds to believe that they were being exposed to a serious risk to health or safety. Now, very important to this is that the Occupational Health and Safety directives that have recently been released on the 29th of April have put in place a number of safeguards for employees and a lot of obligations on the employers to make sure that employees aren't exposed to health and safety risks during this period of time. So if an employer doesn't comply with these directives, I would say that essential service employees and all employees, whether or not they are truly classified as essential services in terms of the broader definition, the broader scope of employees being required to go back to work, in those circumstances, I think they could well refuse to return to work if the employer isn't complying with these new directives. Just one final question on this slide. What about support staff? Yes, we know that doctors need to go back to, or have had to work throughout, nurses, paramedics, but what about this admin, the support staff to those essential services? Can they then be required to work during this period? And again, the answer is yes, they can. They are support to essential services, which brings them under the net, the framework of those essential services, and they most certainly can be expected to work and are required to work under those circumstances. And then the final slide is just very briefly to fill you in on the recent directive issued. It's gazetted on the 29th of April 2020, and puts in place safeguards for employers and employees, with employees now returning to work. In some way, they're extremely onerous. There's a lot of obligations on the part of an employer. Some of these obligations are reduced when it comes to smaller companies with 10 employees or less, but the general ones apply throughout, and they require an employer, and this is second bullet point in terms of Section 8 of the Act, that every employer, and this is applied prior to lockdown, prior to COVID, every employer is required to maintain and provide, as far as reasonably practicable, a working environment that's safe and without risk to the health of its employees. And this involves all sorts of steps required on their part to eliminate, mitigate any hazards at the workplace, provide information, instructions, and training and supervision where necessary to employees at work, and then putting in place measures necessary in the interest of health and safety. And these measures have now been set out in terms of these directives. And I won't go into the full details because it's a long, long list, but essentially all employees need to be provided with personal protective equipment. That's, in other words, they need to be given masks, they need to be given sanitizing products. In fact, the regulations talk about an enforced social distancing gap of 1.5 meters between employees. And if that is not possible, putting up physical barriers between the various employees so that they are socially distanced. They've also made suggestions about employees perhaps looking at staggered shifts or staggered working times to minimize the number of employees working at any particular period of time. Employees over the age of 60, which are a more vulnerable group, have been actively encouraged to stay at home or work from home during this period of time. There's even a section that's dedicated to ventilation and how ventilation should work, because we're all very reliant in Durban on our air conditioning and pumping air-conditioned air into an office with that circulating air, and that in itself is now becoming an issue and will be prohibited in terms of the Occupational Health and Safety Act. And this extends further than simply monitoring employees who also are required to undergo temperature testing and all sorts of physical screening when they come to work, but also as far as suppliers or clients or customers entering a workplace, those same safeguards and precautions have been are required of an employer so that employees aren't put at risk by those particular non-workers, non-employees entering the workplace. One thing that's been a concern is that the Employment Equity Act has a provision in its Section 7 that says that employees cannot be forced to undergo medical testing. This has always been the case. So employees, for instance, that are required to take a breathalyzer test or a blood alcohol test, if they don't agree to it, they cannot be forced to. It's part and parcel of the constitutional protection of bodily integrity, and that's not something that can be done without the consent of an employee. Now we face a situation that has now become mandatory for every employee to subject themselves to medical testing. What if they refuse? Well, if they refuse, they cannot be forced to undergo medical testing, but by the same token, an employer cannot allow those employees into the workplace, and they will simply have to be sent home and not allowed access. Whether that constitutes insubordination or not remains to be seen, but it is a possibility that it's not involves not following a reasonable instruction, and unless there's a reasonable explanation for an employee to refuse to undertake medical testing, I think it could well constitute insubordination. So that brings me to the end of my input. I hope that's helped. Every day something changes. Every time I switch on the computer, there's something new gazetted. So I can't guarantee that this is going to be the status quo in a week to come, but this is as current as it gets up until the 29th of April, the amendments that are in place. There is, Sarah, I'm not sure if you want to put up the final poll question, just feedback, or are you're not going to do that? Yes, okay. Just as far as rating the session goes. If you'd just like to rate us, whether you're happy with our webinars, very good, good, average, fair, and non-satisfactory.
So far, it's looking like you did a good job today, Tammy. 69% very good, 28 good, 3% average. So
very upset
good
about
job.
that. Thank you very much. The last slide we have up here is upcoming webinars. You just want to have a look and see what else we've got coming up in the weeks to come. We've got one on retrenchment in short time on the 12th of May. That obviously deals with the fallout from COVID. And then a range of webinars on mindfulness, dealing with stress, compassion, and connection in the weeks to come.
And then there are a few questions if you want to go through them.
Yes, if anyone has any questions. Sarah, nothing's coming up on my side. You might just have to read the questions to me.
Okay, we have one from Cindy. Hi, with regards to precautionary self-quarantine, would this come from paid sick leave first before approaching UIF for benefits?
Okay, thanks, Sarah. See, these questions have now come up. That's perfect. So, Cindy, with regard to precautionary self-quarantine, yes, this would first come out of paid sick leave, but at the same time, the employer can claim benefits and credit you the sick leave back. So it's completely up to the employer whether they want to claim benefits and credit that sick leave back, because it's of the unusual situation and the fact that TERS makes provision for sick leave compensations in those circumstances. Mohammed, yes, the recordings will be made available online. Thank you for asking. Grant, let me see what your question is. What does one do if an employee over the age of 60 who's pregnant insists on returning to work despite them falling into a higher risk category? I assume that they should be allowed to do so in light of there being no legislative provision. That's a very good question, and it's actually been asked of me recently on several occasions. What I would recommend from an employer's perspective is that they cannot stop an employee returning to work. But I think from an employer perspective, they need to advise their employees that they are at risk, that there are difficulties with their returning, and perhaps just confirm in writing that they have cautioned their employees in those circumstances. They'd also be able to be extended the benefits of the health and safety protections, the masks and social distancing, and perhaps that an employer would in those circumstances have to give even more attention to that in those circumstances. Jonathan, I see a question from Jonathan. Question is if I could clarify whether non-live-in domestic workers may return to work if they're performing child minding or attending to the sick. Do they have to be live-in and be performing such services? Well, there's the million-dollar question. It's one that I'd also like to know the answer to. It's quite a conflict between the provisions, because level 4 specifically says only live-in domestic workers may return to work. And then I've read on several occasions that where there is carer obligations, those will now be regarded as, in a sense, essential services, and those particular domestics will be entitled to return. There is also the provision that is domestics can return to work if they are supporting level 4 employees. And in my interpretation of that, that's probably the loophole, that if level 4 employees have got to go back to work now and they rely on childcare domestic workers, I think that would probably be the loophole where domestic workers would be able to come back to work in those circumstances. But it's just my opinion. I certainly don't have the definite answer on that. And then I see one more question from Zama. What are the recommendations on steps to follow for locums, freelancers, and part-time employees? Well, it's difficult to lump all three of those together. Part-time employees are employees just like any other. So they are entitled to all the benefits. They're entitled to the TERS benefits. They're entitled to the same leave provisions that have applied. They're entitled, part-time employees ought to be registered with UIF. Certainly the employer should be registered so they'd be able to claim TERS benefits on their behalf. But locums and freelancers very much depends if they are classified as employees for the period of their freelancing contractual work, whether they're there in terms of a fixed term contract or not. Because if they are independent contractors, they're not employees, and unfortunately they do not fall under any of the protections of the labour legislation. I would say locums also pose that problem. If the locum is employed in terms of a fixed term contract, for instance, someone's taken maternity leave and they're employed for 6 months as a replacement, they would be employees for that 6-month period, so they would be covered. But if they're simply coming in as an independent contractor, locum, with no employment relationship, they would fall outside of the labour legislation. So much depends on the contractual arrangement that applies in that situation. Right, so it looks like that's the end of the questions. If there's no further questions, perhaps we could end off.
Okay, yes, thank you, Tammy. Just like to say thank you again for presenting today, and we are looking forward to your last webinar taking place next week. I don't know if you're relieved or want to do more.
I think technology is not for me. I'm of the dinosaur era. I'm better with face-to-face. But anyway, we got through another one without too many technological hitches.
Yeah. Yeah, and as Tammy did say, the video and the slides will be available on the UEL website. We will send out an email once we have uploaded it, but it should be towards the end of today. So thank you for joining us, and also take note of the upcoming webinars. You need to RSVP for each one to secure your place. Next week, Tammy will be back with her last webinar on retrenchments and short time, dealing with the fallout from COVID-19. And then we will also be launching a new series the week after that, Resilience Through Mindfulness. And this will be part 1, the introduction. So apart from that series, as you'll see, it's a 4-part. We have 2 more series that we are launching. One on nutrition and dealing with stress through COVID-19, and another one on change management, particularly dealing with the different changes we're encountering through this COVID-19 pandemic. So do keep a lookout on our website for these upcoming webinars. We also have a few online courses we're offering during lockdown for free. So we're sharing our own courses as well as partnering with other organizations in order to provide free access. So please visit our website on www.ukznextendedlearning.com to see what we have on offer. So otherwise, we hope you enjoyed the session and stay safe, and we'll see you next time.